Hello, my name is Galina Ward. I'm one of the public law silks here at Landmark Chambers, and with me is Semakula, who is one of our excellent junior tenants, also in the public law team. We're going to talk today about costs in judicial review, in particular funding and cost protection. And Joel's going to start just by introducing the subject in general terms.
Great. So in general, the loser of a judicial review case is ordered to pay the winner's costs of bringing or defending the case. So as a result, prior to bringing a claim for judicial review, the claimant must budget for two types of expenditure. First, their own lawyers' fees and expenses, which they have to pay in any event. And second, the other side's legal fees and expenses, which they are going to be likely to have to pay if they lose the case. Now, it's possible for a claimant to agree a fixed fee with their own lawyer. However, they will have no way of quantifying their opponent's costs in advance. Those will usually include the cost of the litigation, of their solicitor and barrister, and any expert or court fees. In general, the total amount could be £30,000 or more, although this is a very rough general estimate. The actual figure could be much more than that or less. When considering judicial review, claimants need to act quickly, as delays due to lack of funds are very unlikely to be treated by the court as a good reason for missing the time limits for bringing a judicial review. Now, there are a number of ways in which to fund judicial review litigation, and Galina is going to start us off here with legal aid.
Okay, so legal aid, I'm sure you know broadly what it is, but for our purposes, it's civil legal aid that would apply to judicial review, and that is defined in the Legal Aid Sentencing and Punishment of Offenders Act 2012, which we're going to call LASPO for the rest of this talk. In sections 9 and 10 of LASPO, civil legal aid means the legal services that the Lord Chancellor is required to ensure are made available under those sections. And those sections refer to the types of law that are listed in Schedule 1 to LASPO. And where a type of law, an area of law, is listed in Schedule 1 of LASPO, it's referred to as being in scope for legal aid. In practice, that means that solicitors can be paid for providing legal services in those categories. There are various different types of contracts and contractual payment mechanisms that apply in different areas and for different schemes. But fortunately, I think the focus of this talk is on who can get legal aid, not on how it's paid. The first important aspect, obviously, is who can qualify for legal aid as a claimant, and Joel's just going to run you quickly through that test.
So the scheme itself is administered by the Legal Aid Agency, and to qualify for legal aid, a claimant must either be on benefits, means-tested benefits, or on a low income, have very little in savings or other assets. So in addition to satisfying this means test, the Legal Aid Agency will need to be satisfied that the claimant has a good case. This will require initial advice from a solicitor who assists the claimant with applying for legal aid if the claimant is eligible and that solicitor is willing to take on the case. Now, only a firm or other provider of legal services can apply for legal aid funding for a judicial review case. Usually, they will need to already have a contract with the Legal Aid Agency to provide legal services in the area of public law. However, it is possible to apply even if the firm's Legal Aid Agency contract is in another area of law, or sometimes if the firm does not have a legal aid contract at all, if it can be demonstrated that it's in the interest of justice for the firm or the other legal provider to handle the claimant's case. And that comes from Regulation 31.5 of the Civil Aid Regulations 2012. Galina's now going to tell us about what's in scope.
Okay, so in contrast to the position before LASPO, for those of us who are old enough to remember that, the situation now is that an area of law is only in scope for legal aid, so legal aid is only available if it is specifically included in Schedule 1 of LASPO. Previously, the situation was any area of law was potentially in scope unless it was excluded. But now you have to refer to Schedule 1 of LASPO, and it's fair to say that's not the easiest piece of legislation to understand, it requires a certain amount of cross-referencing and navigation of double negatives. But for our purposes, the important point is that by paragraph 19, it includes judicial review, subject to some exclusions, in particular, certain types of immigration claim where there's been a recent decision or failed appeal aren't in scope, and also a case isn't in scope if it won't benefit the individual claimant. It is possible to get funding in such cases, or potentially possible to get funding in such cases through the mechanism of exceptional case funding, and that's what Joel's going to talk about now.
Indeed, as a junior, I've been involved in cases where there have been applications made for exceptional case funding. Now, that was introduced by Section 10 of LASPO for non-inquest cases that are not in scope for legal aid. It should be available for claimants' human rights or retained EU rights would be breached if they do not get funding for a lawyer. Now, the test here is whether a claimant could present their case effectively and without unfairness if they do not have legal aid. When you're making applications like this, that test is likely to be satisfied if you're dealing with a case, for example, where it's particularly complicated, the claimant's not able to deal with it alone, or the importance of the case to the claimant is such that it will be unfair to have them manage the case themselves. In order to be granted exceptional case funding, the claimant will also have to demonstrate, again, that the case is strong enough, just as with regular legal aid, and that they are financially eligible. Applications for exceptional case funding cannot be granted, however, by the firm or the legal provider with the contract, and those also have to be sent to the legal aid agency. All of the relevant forms can be found on the gov.uk website. The legal aid agency's target time for responding to exceptional case funding applications is 25 working days. Now, when you're dealing with an urgent application, that time frame falls down to 10 working days. If you happen to end up in a situation where you get an unsuccessful application for funding, the claimant can apply for an internal review of the refusal by submitting grounds of review and supporting documents to the legal aid agency. Now, if that refusal of funding is upheld on an internal review, the only way of challenging that is, you guessed it, again, by judicial review. The Public Law Project has a number of resources to assist claimants and their lawyers with making exceptional case funding applications. But I guess now it's interesting to think about, well, what happens if a claimant does not qualify for legal aid?
Well, first of all, of course, they might be able to privately fund the claim. Obviously, that involves having enough money not only to cover your own costs, but also, as you said at the start, potentially those of the other side if you don't succeed. But one quite popular approach recently has been to crowdfund to raise money from the public through a site like Crowd Justice. That was used successfully by Reclaim the Streets, for example, in the challenge to the policing around this Sarah Everard vigil, and I understand that there's other challenges going to be brought about that are the subject of crowdfunding currently, and it's a way that the Good Law Project, which is an organisation that brings quite a lot of judicial review challenges, funds a number of those challenges as well. The Good Law Project is also, or will sometimes, fund cases brought by other litigants if they approach it, so it's potentially worth looking at the Good Law Project's areas of interest and whether they extend to the sort of challenge you're thinking of bringing. There's another potential source in the immigration context is the Strategic Litigation Fund that is run by the Immigration Law Practitioners Association, ILPA, and the information about that is on their website, but very briefly, they will sometimes make grants to organisations either to undertake pre-litigation research or to support third-party interventions to ensure that key legal points, particularly those that affect the rights of migrant groups, are made in existing cases. So they won't fully fund a judicial review claim, but you might be able to get funding that will get you in a position to see if it's worth going down one of the other routes or to support an intervention in a particular case. Another potential arrangement, if you can't find a source of private funding is that some solicitors and barristers might agree to act on a conditional fee agreement, a CFA, which means that they won't charge either any fees or their full fees unless the case is successful and there's an order that the opponent pay the costs. That, of course, only protects you from the liability to pay your own lawyers. Again, it doesn't protect you from having to pay the other side's costs if they lose. And it's also worth saying it's very important if you're running a case on a CFA to make sure it's properly documented in a way that conforms to all the rules, because otherwise you won't be able to make that claim for costs against the other side.
Moving on now to pro bono. Now, some claimants are able to get free help from a solicitor or a barrister, for example, via the bar pro bono unit. However, this does not protect the claimant from the risk of the other side's costs being awarded against them if they lose. Now, when you're acting pro bono, it's important to be aware of pro bono costs orders, which are the same as ordinary legal costs, but are available where a party received free of charge legal representation provided by a solicitor, barrister, or advocate in England, Wales, Northern Ireland, or Scotland. If a judicial review case is won with pro bono help, pro bono costs can be ordered by the court or tribunal or included in settlements. The order covers any period when free of charge representation was provided, and the amount is based on what a paying client would recover. Now, unlike ordinary costs, pro bono costs are by statute payable to the Access to Justice Foundation. You find that in section 194 of the Legal Services Act. And that the foundation there distributes the money it receives to agencies and projects that give free legal help to those in need. Now, the procedure for seeking a pro bono costs award is the same as seeking a normal costs order. Once you win an application, a trial, or an appeal, the pro bono lawyer or the litigant in person should ask the judge to order costs against the losing party. Now, back to section 194 of the Legal Services Act, that's where you start, and then the process of making an application is supplemented there by CPR Part 44, in particular Rule 44.3C2, which sets out how the court may determine the amount of pro bono costs to be awarded. And that amount is based on what a paying client would recover. And if you go then again to paragraph 10A of the Cost Practice Direction, it provides that the general cost rule applies to pro bono cases, namely that the court should make a summary assessment of the costs unless there is a good reason not to do so. So if you're dealing with a case pro bono, there's some things you should remember as you're going through the management of that case. The first is it's important to highlight your ability to obtain pro bono costs if you win, as this can be helpful strategically to settle the case because it shows the other side that there still remains some costs risk. You should record the hours that you've worked and file and serve a statement of costs. You don't have to use court form N260, but you should show what it would have cost a paying client at your normal rates. Once you're done, ask the court for a pro bono cost order under section 194 and CPR 46.7. And once you get that award, don't forget to tell the Access to Justice Foundation when you actually secure the pro bono costs. The foundation actually has some very helpful guidance on making these applications on their website.
Thanks, Joel. So those, broadly speaking, are the various ways of funding a judicial review. What we want to talk about now is cost protection, so how to avoid having to pay the costs if you're not successful. The first area where cost protection applies is if a claimant is legally aided. Then under section 26 of LASPO, they're protected against the risk of paying the other side's costs. And that's obviously a statutory protection that will apply in all such cases. If the claimant is not legally aided, of course, the general rule is that they will have to pay the other side's costs if they lose. But it is possible to ask the court to make an order that limits or even extinguishes that liability. The first major provision that applies to that is under the Criminal Justice and Courts Act 2015 in sections 88 and 89, which make provision for cost capping orders in public interest cases. So a cost capping order is an order that the court can make at an early stage of the proceedings to either limit or remove the liability of the party to pay the other party's costs in a judicial review claim. An application for a cost capping order can only be made by a claimant, not a defendant, or an interested party or intervener. They are often applied for by non-governmental organisations, such as charities, who are seeking to bring a claim to clarify the law on behalf of their client group. There's provision in Part 46 of the CPR for cost capping orders in judicial review. In Rule 46.17, the requirements of an application for such an order are set out, and Rule 46.19 deals with applications to vary. Now, the usual procedure, and this is also set out in the Administrative Court Guide, is that the application for the cost capping order needs to be made in the claim form, and any response, opposition to it, or submissions about it need to be made in acknowledgement of service. The court will then look at all of that when it decides on permission. If permission is granted, may make the cost capping order. That order can be varied retrospectively, and there's a recent case that I was involved in, the Anti-Trafficking and Labour Exploitation Unit against the Secretary of State for Justice, which is frankly a cautionary tale if you're a defendant of how not to approach these matters, but did nonetheless establish that the court might retrospectively, in exceptional circumstances, exercise the power to vary the cost capping order. But the key thing is that you should follow the proper procedure as set out in the CPR and the Administrative Court Guide. As to the substance, before it grants a cost capping order, the court will need to be persuaded of a number of things, including, most importantly, that the case raises important issues so that it's in the public interest for it to be heard. So, for example, it might clarify the law for many other people, not just a particular claimant. And also, and this is where the point of contention very often arises, that without a limit on the amount of cost the claimant would have to pay if it lost, the claimant could not afford to proceed with the claim. So the claimant will need to put in evidence that if a cost capping order is not made, the claim will not proceed. It will feel that it has no option but to withdraw, and the court will assess whether that's a reasonable position for the claimant to take. If it's persuaded to make a cost capping order, the court will limit both sides' cost liability. There's a requirement in section 89.2 of the 2015 Act. There is some form of reciprocal cost cap, but not necessarily a precise mirror. The court will generally expect that some part of the claimant's representation is pro bono before it makes a cost capping order. Two difficulties, two aspects of cost capping orders that can be problematic. Firstly, of course, you don't know when you issue a claim whether you're going to get a cost capping order at permission stage. So until that point, you're not at risk very much of the other side's cost, because of course it will only be the cost of acknowledgement of service at that point, but you are always taking that risk if you issue. Secondly, there's a requirement that the outcome of the case doesn't benefit the individual claimant, or at least it's much less likely that an order will be made, a cost capping order will be made, if the case will benefit the particular claimant. Of course, if the case does benefit the particular claimant, it's more likely to be in scope for legal aid, so there is a trade-off there, but something to bear in mind. Finally, I think Joel's going to talk about cost capping orders in environmental claims.
We're seeing a lot more of these types of claims being brought at the moment, and in the work we do, particularly also in the planning and infrastructure world. But under Article 9 of the Aarhus Convention, the cost of litigating certain environmental cases must not be prohibitively expensive. Now, to comply with this obligation, claimants in environmental judicial review cases can choose to restrict the costs that they would have to pay the other side if the claim fails. The caps only apply where the claimant is a member of the public, and this includes natural persons, corporations, and unincorporated associations, but it doesn't include public bodies, and the detail of that can be found at CPR Part 45. The current cost limit is £5,000 with the claimant is claiming only as an individual and not as or on behalf of as a business or other legal person. And in all other cases, the limit is £10,000. And when I've been involved in environmental judicial review claims, there's been a really important consideration strategically when we're considering who to choose as a claimant. Now, where a defendant is ordered to pay costs, their limit is of £35,000, and both sides can apply to the court to amend these figures, and that's again pound rather than pound in CPR Part 45. A claimant who believes that their claim is an Aarhus Convention claim and wishes to apply for a cost cap under these provisions must note that in Part 6 of the claim form and file and serve with the claim form a schedule of their financial resources, which is verified by a statement of truth. I think that brings us to the end.
I think it does. Thank you very much, Joel, and thank you all for listening.
Thank you.